founder, CEO of Omega Healthcare. We treat mental health and addiction. Reading statements from two parties who are not able to be here today. They're out of town.
As you get into this, let me state, due to the number of speakers that we have, I'm going to adhere a little closer to 3 minutes. So
3 minutes total?
Yeah.
Okay, I'll read fast. My name is Lauren Walker. I'm a parent whose life was devastated by an unethical custody evaluator. I have a beautiful 6-year-old daughter, and we haven't seen each other since July 2018 when a jury terminated my parental rights. I went from my daughter's primary caregiver to being removed from her life altogether in less than 2 years. My family spent over $1 million defending me in the custody battle, 17 hearings in all. That was fueled by the custody evaluator's continual recommendations to the judge. I was beaten badly by my ex-husband, which I've seen the evidence and videos of that. I experienced a traumatic brain injury from him kicking me in the head with his boot. My daughter and I, at one point, received a protective order to keep us safe from my ex-husband. When I left him, he continued to use the court system to abuse me. The termination petition was instigated by my ex-husband, not the state, and the idea to terminate my rights originated from the custody evaluator who grossly exceeded her scope and violated the rules as well as the code of ethics. Not once did any other professional recommend that it was in my daughter's best interest for my rights to be terminated, yet that's what happened due to the custodial evaluator's actions. Dr. Jonathan Gold, who is a renowned forensic psychologist, reviewed by Dr. Alissa Sherry's evaluation reports. I have a 27-page report with details of his findings. He concluded that her report was completely flawed and did not qualify as a custodial evaluation. Dr. Gold cited concerns about the information included and excluded from the report, for example, the inclusion of a speculation and hearsay opinions and the exclusion of direct observation of parenting, failure to assess critical parenting attributes, which was the purpose of the evaluation, misuse of psychological tests, use of unreliable methods and lack of scientific-based findings, and notable differences in the treatment of the parents. Dr. Gold recommended that the jury should not use the evaluation as evidence to support its decision. My daughter's and my story is terrifying and heartbreaking. In closing, I plead with this board to conduct strenuous oversight and investigation of its forensic psychologists involved in family court cases to prevent this tragedy from happening again and to correct cases that have already ended in tragedies. Thank you, Lauren Walker. There's an expert opinion here from Dr. Jonathan Gold. I don't know if I should read that or then the next statement.
You made your point.
Yeah, there's one more statement. Should I?
Okay.
And this is a short one. Our names are John and Gay Walker. We reside in Arizona and are unable to attend in person. Our family has been irreparably harmed by the seriously flawed custodial evaluation conducted by Dr. Sherry and her unethical behavior. Our daughter's parental rights were terminated after a 2-week jury trial. The judge refused to terminate rights after the evaluator requested a court order to recommend termination. The judge voiced her concerns about our granddaughters having abandonment issues. The evaluator's testimony at the trial was extremely damaging. As a result of the termination, we have lost all contact with our 6-year-old granddaughter, even after multiple requests. Up until the termination, we were in constant contact with her, and she was well aware of her Arizona family. We have been erased from her life. We were never allowed to tell her goodbye or do not have any idea of what she's been told. I'm not sure how any evaluator believes that this is the best interest for the child. The problems I are seeing extremely costly, lengthy, drawn-out custody evaluations spanning over 2 years from July 16 to August 2018. The evaluator's initial contract estimated the cost to be $20,000. The total cost at the end of the litigation and jury trial was $230,000. Solution: place time restraints on evaluations, enforce court order timeline. Place a cap on the amount of evaluator is allowed to charge. Point number 2: my husband and I were never taken seriously as interveners. As co-conservators with our daughter. The evaluator never followed through on a home visit that we offered at our intended place of residence in Austin, nor was my husband ever observed with our granddaughter in any capacity. The evaluator never spoke to any members of our family and did not ask for collateral witnesses. Solution: request evaluators equally consider all interveners as possible placement of the child. And the last point, the evaluator's report was extremely biased, contained hearsay, multiple errors, contradictions, assumptions, and running together of stories. A letter submitted correcting errors to evaluator via our attorney was never acknowledged or corrected on the record. Solution: request the ability to read individual interviews and make any corrections prior to the final report being submitted. Request all communication between evaluator attorneys, including ad litem, and all parties via email and made available to all parties involved. Any telephone conversation should be recorded, no ex parte. I think it would be negligent of the board to dismiss complaints against psychologists who are involved in family court cases that have lasting and devastating consequences to children's parents, grandparents. More oversight, restraint, and direction must be provided. And I'll finally say, I know the party pretty well. I've never seen this kind of, I don't know y'all's field, but there's some major corruption going on. Just as an outsider observer, I'm really surprised at what happened in that case. She's a good person and a good mom. That never should have happened to her. And the really everlasting effects are going to be to the child. So, thank you.
Michelle, you know